Good afternoon, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Wanted to talk to everybody today about the franchise of a birth certificate, of course. And so we're going to look up what franchising is. Oops. And when we look at Investopedia's definition of what a franchise is, it says, what is a franchise? A franchise is a type of license that a party, franchisee, acquires to allow them to have access to a business's, franchisor, proprietary knowledge, processes, and trademarks in order to allow the party to sell a product or provide a service under the business's name. Are you a U.S. citizen? Do you actually have a valid franchise through that birth certificate, or is it just presumed, implied, and assumed? Is the actual process validated? Has it been put in, on, and for the record in exactness, in correctness, so that you are actually a true and valid franchisee of the franchisor known as the United States, acting as a United States citizen? Is that why you claim to be a United States citizen? Or do you just claim it because that's what you were told to? See, when it comes to this birth certificate and this indoctrinated belief that you're a United States citizen, that United States citizen means that you're a franchisee of the franchisor United States, which is a corporation. Okay? Now, back to this definition, a franchise is a type of license that a party, franchisee, the one with the birth certificate, acquires to allow them to have access to a business's franchisor. The business is United States. They are the ones that produce this birth certificate through banknote companies. Now, that's proprietary knowledge. It's a proprietary process and involves the trademark of the United States. In order to allow you to sell a product or provide a service under that name. So as you operate as Keith Orland Little, the United States citizen, or the state citizen in franchise with the United States citizen under the 14th Amendment, dual citizenship, as a franchisee for the United States. Does that make sense to everybody? In exchange for gaining the franchise, the franchisee usually pays the franchisor an initial startup and annual licensing fee. And this is what we're talking about. Let me see if we can find definition of franchise relationship in Title 15, which is your contract code, your commercial code for the federal government. Let me see here, what do they title it? Federal and state laws, U.S. Code, Commerce and Trade. Title 15 of the U.S. Code is in relation to commerce and trade, and it says franchise relationship. And this is a very important as definition under C in this section. Let's tell you here. 15 United States Code, 15 USC 2802 talks about franchise relationship, and it's got 4 sections, A, B, C, and D. And under C, there is a definition. As used in subsection B2C of this section, the term, an event which is relevant, related, to the franchise relationship, related, and as a result of which termination of the franchise or non-renewal of the franchise relationship is reasonable, includes events such as, listen to this, guys. Number 1, fraud or criminal misconduct by the franchisee relevant to the operation of the marketing premises. Fraud or criminal misconduct by the franchisee relevant to the operation of the marketing premises. Did you comprehend that? An event which is relevant to the franchisee relationship. The first transaction that is relevant to the franchise relationship is the day you were born. A statement, a born live statement, was made up in which people put handwriting on. And they were known as informants. And that handwriting included measurements, weights and measures, and a particular given name, along with a heretical name. Generally, of both mom and dad is what is supposed to be accepted, but also accepted is just that of the mother for bastard children. Okay? An event which is relevant to the franchise relationship. When you were born and they made that live born statement, what they did next was they took abstract information from that form and placed it on another form called the long form, or short form, certificate of live birth, where it has the information, mother and father, the all caps names, upper and lower case names of mom and dad, the 2 signatures of the state registrar general and the, I believe it's the governor on the birth certificate. Now this is done as an award. You are awarded a franchise of the United States, known as the United States State Citizen Dual Citizenship, so that you can operate commercially within each state internationally and with the United States intranationally. That's what the dual citizenship is about, and the birth certificate is an award. It's a security certificate, a certificated securities instrument, allowing you to use the trademark United States by claiming you are a United States citizen, and thereby performing commerce under the United States. Pure and simple. Now, my take on all of this is that upon the age of majority, as most people know it, upon the age of discretion, as I discern it, one is to step out of Babylon, put down childish things and put down childish ways and become an adult and prove to the world that they are an adult. And they can do this in several ways. One of which is to accept the franchise and take an oath of allegiance. Now that they are an adult, they can make that such contract. If they do not make that contract, if they are unknowing of that contract, and they continue on in life, as many of us have, and they're pulled into these court situations, based upon this, is in my belief, in my opinion, that we are as franchisees, presumed franchisees committing fraud and criminal misconduct relevant to the operation of the marketing premises, which it is premised that you are a United States citizen and therefore using the United States trademark. And you are the one acting in wrong, behaving wrongly. That is the presumption. We nearly need to rebut that presumption. Now, as used in subsection B2C of this section, the term an event which is relevant to the franchise relationship and as a result of which termination of the franchise or non-renewal of the franchise relationship is reasonable. When we talk about termination, we're talking about events of fraud. And that's why this first one mentions fraud or criminal misconduct. When we talk about cancellation, we're talking about this next element, which is the non-renewal of the franchise relationship is reasonable, includes such events as, second one, is declaration of bankruptcy or judicial determination of insolvency of the franchisee. Okay, now let me help people comprehend this one right here. No man can go through bankruptcy if they're operating or even presumed to be operating under a franchise that is already insolvent. Does this make logical sense? So by right, even number one, fraud or criminal misconduct by the franchisee relevant to the operation of the marketing premises, that one should be struck from the record, because that is an impossibility for a franchisee to commit fraud under a franchise itself that is itself insolvent. Comprehend this, people. If the United States is actually not insolvent, then they must bring forth that record. They must show the money. Show me the money. Show me the substance backing that money. If they have no substance backing the money, then there is no body of trust. Therefore, even as a trademark being insolvent, there is no such thing as fraud on behalf of the franchisee, particularly if that franchisee is authorized representative through the Uniform Commercial Code, who clearly identifies that the authorized representative giving an unambiguous authorized signature on an instrument is not liable for the person named in the instrument. Why is this? Why is this? Because if you comprehend this stuff correctly, you see that if a termination is based upon fraud, then it's our determination that it should be based on fraud, because the United States corporation providing these franchises is insolvent and therefore cannot provide a franchise to begin with. So no matter how they try to create any kind of parity, this birth certificate as a financial instrument is exactly that. When you step into that, you are claiming there is a debt. If they are insolvent, then they can't hold a profit or a debt. They do not exist. The only way the United States exists is through operation of process and the people that are operating, acting in the capacities to perform the functions of those public offices. That's it. Period. And that, of course, is why they have the Federal Acquisitions Regulation. Again, I'm going to point out that one, That's part of Title 48 of the Code of Federal Regulations, Part 52.212-5, which states, quote, contract terms and conditions required to implement statutes or executive orders hyphen commercial items. There must be a contract, and there are many elements to a valid contract, one of which, and they are all required, 7 elements that are required. I believe there might even be 8, I'm not sure. I'll have to check that again. But of those required elements, one is 2 wet ink signatures. Now, on that birth certificate, like I said, there are 2 signatures. They are copied, and if you try to trace them back, you're going to find out that those 2 signatures on that document don't match the 2 signatures on the document at the county courthouse, wherein the registrar signed it along with the doctor. Now, that document isn't going to match the document at the hospital that was signed by the doctor and another informant known as the mother. See, their chain of title, their chain of custody, their chain of evidence, their chain of franchise is totally non-existent. And so I urge you people to do your research and read this stuff and comprehend. So when we look at the word termination, or the term termination, in regards to these definitions that they're using in a federal code, look up their terms and conditions of their contracts on international sale of goods defines termination and cancellation. Termination involves elements of fraud. Cancellation includes elements of non-validity or detriment or something like that that would cause a non-renewal. Correct. The United States exists in name only. If they're professing that they have any kind of trademark on the name United States, they can't possibly do that. How can a company that is insolvent renew a contract unless they're put in debt by another entity and yet still claim some kind of authority over you? If they are themselves insolvent and in debt, and you're professing to stand in that same debt, now who's your authority? Is the United States your authority, or is the one that they are under debt to your authority? Where does that chain of command stop, and where does it start? It doesn't exist except in name only. So think about this stuff, people, and comprehend. This isn't really a long section. It's longer than what I'm going to read to you in entirety, but I wanted to read that particular section in regards to franchise in relation to the commercial transactions that we're doing, the secured transactions that we're doing. You know, like I discussed in my last video, we're all secured party creditors initially. That is the only way this United States corporation gets any kind of credit. And they're using that credit to pay off supposed debt. But they're not paying off their debt. All they're doing is paying off the interest on that debt, and you're helping them by giving it up freely and willingly. And they're holding it over your head every time you go into court. It's a presumption of mine that the states are acting on the presumption that you're acting as a franchisee using that corporate name in all caps letters. Can I see your license and ID, or license and registration, please? Sure. And both of them are in all caps letters under the dual citizenship of the state citizen United States 14th Amendment contract. So think about this stuff, people. And I'm going to read this one here. B of this same section, before we got to those definitions, says precondition on grounds for termination or non-renewal. And remember, I just discussed that the birth certificate itself has a governor and state general or registrar general's signatures on it, whereas the live born statement at the county registrar is going to have the county registrar and the doctor's signature on it. And then the Born Live statement itself at the hospital is going to have the doctor's signature and the informant's signature. And that's also going to be recorded at the county courthouse with the certificated form that the state or the registrar then sends to the state for them to draw up their certificated form, which is the certificate of live birth. So the hospital has a single record. The county register has 2 matching records. The state Secretary of State has 2 matching records. And then you yourself should have both of those matching records. One from the county, the Born Live statement, and the birth certificate. Now you've got a matching record showing false signatures, showing that the precondition and grounds for termination or non-renewal exist because there is no direct tie to yourself. But there's a quandary, a quorum of witnesses that will supposedly get on a stand, but yet will never do so because they're going to get on the stand in a personal capacity for an entity that doesn't really exist except in name only. Imagine that. No liability. And again, this is, why you're not liable under UCC 3-402B Part 1. Nobody's liable because the corporation does not exist. Any franchisor may terminate any franchise entered into or renewed on or after June 19, 1978, or may fail to renew any franchise relationship if the notification requirements of Section 2804 of this title are met. Such termination is based upon a ground described in paragraph 2, or such renewal is based upon a ground described in paragraph 2 or 3. But we don't see paragraphs 2 and 3. That's funny. Okay, so for purposes of this section, the following are grounds for termination of a franchise or non-renewal of a franchise relationship. Failure by the franchisee to comply with any provision of the franchise, which provision is both reasonable and of material significance. What's material? Well, that's the matter. That's the subject matter. To the franchise relationship, if the franchisor first acquired actual or constructive knowledge of such failure. Okay, what this is telling you is that this franchise, quote, franchise, is operating as a franchise and allowing you to act as a franchisor until you tell them that you recognize that you're not actually a franchisee. Because you don't meet certain requirements. You didn't comply with certain requirements. What's one of those requirements? Oh, I haven't taken an oath of allegiance. I haven't renounced my prior given nationality as an American. To become a legitimate partner, being party to a franchise-franchisee relationship. I've never taken that oath. I've never filled out an application for a government job. Knowingly, willingly, and intentionally. I've never filled out an application for a job knowing that it was directly related somehow to the government other than some kind of perverted requirement for taxation, which I have always tried to rebut in the best manner that I could and have successfully just not paid it for the last 15 plus years. And I didn't file any paperwork or anything. I just quit paying. Now, remember earlier in that definition we talked about bankruptcy? Declaration of bankruptcy or judicial termination of insolvency of the franchisee is a reasonable termination or non-renewable excuse. And I have declared bankruptcy. Now, from that point on, I did get a renewal of the driver's license. But I still held in my possession a birth certificate from 1998, which I then turned around and turned into this last case 4 years ago. So I don't know what any of that has any effect on it, but I will say that it's a matter of stepping up and learning this stuff so that when I do get back into commerce, I don't have that falling back on me because, like I said, I haven't filed any paperwork in regards to the IRS and non-payment of taxes. I just quit paying. Yes, Brian, we are, and this is what I try to. Let me talk about, and I'm going to insert this thing about the Penhallow versus Doan's administrators case. It's a quote that goes around quite a bit, and I made a mistake in my early research of posting it and going by it, in which it states that the fiction is foreclosed from creating parity with the tangible. And though that makes very, very good common sense, it was never quoted in that particular session of Congress, July 13th, 1967. But what was quoted in there was two facts. One is that the 14th Amendment was never properly ratified, as well as the acts of Reconstruction were never properly passed, and they are invalid. They are not valid. And when we talk about the Reconstruction Act, we're talking about the overlayment of the federal government onto the states. Because in order for the federal government to operate as a federal government and allow the internal states to contract with each other and the international forum, there has to be a dual citizenship. Because in order for the federal government to act as a franchise for the rest of the states of the Union as republics, and this is where it went wrong. It's not acting as a franchise under the states. It's acting as a corporation and franchising the states. Totally backwards. And that's the same with the nationality and stuff. Each state has its sovereignty. Okay? No matter what discussions anybody wants to have, each state has its sovereignty. But merely, again, because somebody defines some kind of fictional border. Because when we think about it, again, that sovereignty lies within the people. And this is wherein the common law steps in. The sovereignty of the people is something that's common within that territory. And that territory is the boundaries. It's the bounds. And when we think about territories, I hope people go back and think about the Federation of Tribes. The tribes that existed in this valley on this side of the mountain had different things available to them for them to use throughout their year as they traveled in and around throughout that valley, up and around the mountains, whatever. And this tribe over here had different things accessible. When they met up and traded those things, it was done under fair trade. They didn't use a commercial system. So the Federation of Tribes, though, was designed so when there was a complication came in and they needed to get past that so both tribes could trade, they had a tribunal that was common. And that tribunal was made of elders, not people that were trained to think about things in a delineated way, but elders that were already learned through experience and had wisdom. And this is what we need to do here. We need to start gaining wisdom, experience in our learning so we can pass that on as wisdom. And that's why I say my truth isn't your truth isn't my truth. So when I tell you that I just quit paying taxes, I don't suggest that you just go out and quit paying taxes. I'm telling you, that's what I did, and so far I've had no repercussions. But again, my path didn't go along the same path as most people. I didn't just quit paying taxes. A few years later, I quit that job and started independent contracting again. And through that and bartering, I just didn't have any need to pay any taxes any further, so it never came up. If I get back into this commercial system and start using those instruments, I have to know the tax levies behind them and the usages of them. I have to be aware of that and say, okay, now in the previous capacity, I wasn't aware, so therefore it was unknowing, unwilling, and unintentional. I was already existing free of levy. And that's clearly again, evidenced in UCC 3-402B Part 1. The authorized representative giving an unambiguous authorized signature on the instrument is not liable for the person named in the instrument. The person is the one that's liable for the taxes. And if I'm not liable for the person, then neither am I liable for the taxes. Period. Plain and simple. So no matter how they construe it, you just got to think about it and put it in its right context, particularly mathematically. Everything is subsequent to something else. And that's why I say that birth certificate with the governor's name and the state registrar general's name on it comes from another certificated instrument that has a county registrar and a local hospital doctor's name on it, which comes from an original born live statement that has the doctor's name and the mother's name on it. And yet, here we have it all being professed under a franchise, supposedly having some kind of trademark, and professing that it has citizens operating underneath it. And every last one of them is fraudulent. And then every last one of them is put on these federal codes and state statutes as an agency, a program, a department, a bureau of such an agency. And they're all seeking economic substance of Federal Reserve notes under that franchise's, quote, authority. So think again, whose authority you're really operating under. Is it the United States or is it Treasury? And I'm not talking about the United States Department of the Treasury. That's different. I'm talking about Treasury. Treasury is the Treasury of the IMF. That's who generates the authority for use of the Federal Reserve notes. So are you actually operating as a franchise of a international organization that's in joinder with a city-state trust? Think about this. That's who you're really setting yourself under, and that's why I say when you become age and majority, you have the opportunity to go ahead and accept that franchise and operate it according to these 8 million codes or whatever. Or you have the opportunity, which is my belief, in my opinion, that you're supposed to terminate it for that fraud. Let them know that you are recording it, that it is fraud, that you collapse that trust and you will operate your own person within the commercial format. According to international law. Because all these, again, everything's uniform throughout all the jurisdictions. Okay? And if everything's uniform throughout all the jurisdictions, wouldn't you want to be the one that holds the highest authority in all jurisdictions? It's time to comprehend you are the highest authority. You're the only one that's ever going to give a signature on anything. And if you think the governor's going to come in and sit on a stand and verify that birth certificate, you're wrong. If you think the registrar general is going to verify the birth certificate, you're wrong. He's going to verify his signature on that document and say that it is relative, it is in relation, it is relevant. Objection, Your Honor, relevance. What do you mean? Well, the governor and the registrar general are neither one related to the county register or the doctor that signed the instrument that sits in the deposit account at the county registrar, whether that be at the whatever particular county bank or credit bureau they have, or credit union they have. And neither one of those names, or only one of those names, is relative to the mother, who is actually listed as an informant, which would be a personal capacity of an employee of the United States already. How can one be an employee or franchise of something that doesn't exist? That isn't actually a franchise. I couldn't possibly go to work for McDonald's if they were insolvent. The United States wouldn't allow them to operate it as an insolvent corporation, hiring hapless victims to enter into that solvency agreement without having any rightful compensation of pay, because there is nothing to pay with, because they're insolvent. So, in essence, the contract itself, the application itself, would be fraud. That's why I say even your quote Social Security application for old age pension fund was actually an employment application, whereas they could classify you as a Medicare qualified government employee. You're not a Medicare qualified government employee. All those statutes talk about the person. And as an employee, you're supposedly operating the functions or performing the functions of a public office. What are the functions of a public office? So if you're performing the functions of a public office, what public function or public office are you performing the contract under? Yours or theirs? Whose authority? Who's the author? Whose autograph? Is it yours? Maybe it's Mark Twain's. Maybe it's Samuel Clemens. Maybe it's Tom Sawyer's or Huck Finn's. Tom Sawyer left his autograph on a white fence. Everything in life is subjective, people. Are you going to subject yourself to it? Or are you going to subject it to you? Are you going to place that authority in the right place? Do you know where the authority exists? Is it insolvent? Does it have substance in that body of trust to make it a true trust? A valid trust? Yeah, stolen identity. What they've done is they've taken a name that you have an inherent right to operate as a commercial business on the international forum. They don't have any right to that name whatsoever. None. Everything's done by presumption, and until you break that presumption and collapse that trust, that is non-existent for the fraud. Terminate the trust. And here again, I'll remind you of a case, 1804 Supreme Court case, and it was ruled in Saunders, Saunders versus Vautier, Vautiers. The beneficiary, the named beneficiary, the intended beneficiary has entitlement to terminate or cancel any trust that he's named in. I'm sorry, just because you thought it was a benefit to me doesn't mean it's actually going to be a benefit for me, because by association and of freedom of association. I don't believe what you believe. I don't believe it's to my benefit. In fact, I believe it's detrimental. Therefore, I do not wish for this to be relevant in my life whatsoever. If I want the name to be relevant, that's one thing. But again, that franchise is according to certain procedures. They have certain bylaws. And they are constructed through 8 million different codes, as far as I can see, under which that franchise operates. And it's been a hard time figuring it out, and I'm still figuring it out. But I do believe that it is not actually relevant to myself, and the record will prove that. The only relation it has to myself is that somebody hypothecated the name. They ran it down a commercial venue because that's the only venue they have available to print it out in. That's the only venue they have reason to keep track of it in. Me, my venue of authority is a family register, a private member association. So when it comes to the naming, particularly when we have our children at these hospitals, we have to put it in the contract that the contract has no proprietary interest. No proprietary interest in the naming or the calling of your heirs. Stop them right at the footprints. That's a very firm and conditional acceptance. You are not allowed proprietary information of the name other than heir or heiress. If at a later date we decide to let the community know, we will provide a public notice. Pure and simple. That's your unlimited power to contract. If they want to offer a contract for registration into that hospital, you're registering yourself. Okay? You can register your woman into that hospital for certain and specific contractual procedures to ensure the health and well-being of your heir and heiress, because they are proper means provided under good faith. Pure and simple. And that's as simple as it gets. You can cut this birth certificate off at the feet, but make sure that if you do, you are prepared by knowing how to operate your own creations of persons. You have to be able to implement these instrumentalities. You have to be able to use Federal Reserve notes. You have to be able to use checks. You have to be able to use promissory notes. And in using those, again, we go back to the authority, the author. Who is writing that signature? You have to qualify the office from which it comes. So when we act in these manners, we have to qualify that signature through reservation of rights of exchange of lawful coin, 12 U.S.C. 411. And this is what actually prevents an incurrence of debt. When we use the Federal Reserve notes, such as like kind of Federal Reserve notes, such as promissory notes, checks, and things like that, without qualifying that signature, it's actually building the U.S. debt. Okay, we're not actually paying anything on it. When we use the Federal Reserve notes, we're paying towards the interest. Okay, we keep circulating that Federal Reserve note. That's a negotiable instrument. And until somebody stops it, it remains a negotiable instrument. And the only way you can stop it is by taking it out of circulation. And this is why I say when you get a birth certificate, having your PMA established, I don't necessarily believe that you have to have it authenticated. I believe the delivery process itself, from the State Bureau of Vital Statistics to the one man that can actually, by law, have possession of it and claim both legal and equitable title, thereby does claim legal and equitable title simply by possession. But again, I emphasize that we should match that title up with the born live statement. And both of those, I believe, will be held at the Secretary of State. Putting those in the PMA and letting them know that that trust is now collapsed for failure to have a true body of trust, exhibiting fraud on the face of the record, is reason for termination by presumed franchisee who is actually, through the public charitable trust, the intended beneficiary. And so when we go back to the subsequent things, the intended beneficiary is the original intent of the Constitution. It is the original intent of the United States in creating the birth certificate. It is an entitlement. It is an award by the United States to the states to create a franchise of which you are given authorized representation to operate that franchise. And then you claim United States citizen and state citizenship by claiming the Iowa residency and claiming that you're a United States citizen. Okay? That's only part of the franchise regulations. That's only part of the franchise bylaws. You have to have a bond. You have to take an oath of allegiance. Depending on what part of the branch of this, quote, government you're being employed by, you have to fill out a certain application. There are various different requirements that aren't being fulfilled, and therefore you can't actually possibly be a franchisee. Along with the fact that the United States can't possibly be a franchisor if they're insolvent. Particularly if they've been insolvent for 70 years at a time. So I really urge people to think about this. And when somebody claims a debt, what are they actually claiming? When somebody claims that you owe a debt, they're claiming that they're under the authority of the IMF. Pure and simple. They're claiming they're under the authority of that world trust, the Vatican, the City of London, and Washington, D.C. Pure and simple. And that's all operated through the UN. The UN, the City of London, and Washington, D.C. convene in London through various different things to implement regulations of the IMF. And, of course, international commerce and trade. International public and private law. So if you want to become, and this is the way I explain Romans 13, if you want to become subject to them, you have to abide by Romans 13 and do as they say. If you're going to abide by Genesis 17, verse 1, I am Almighty God. So long as ye follow my way, ye shall be blameless. Then you walk on the water. You follow the true word of God, and when there's a problem, when you find a problem, you go to your brother and you talk to him about it. You ask him, well, in complete, total, rational, logical sense, you ask him, well, isn't there supposed to be a particular set of joinder throughout these transactions showing the origin? And that set of joinder that we see here has no actual signature that is actually relative from transaction to transaction to transaction to transaction to transaction, let alone the fact that as a minor, I'm not allowed to contract until I'm 18, so my signature didn't actually show up on the record until I was 18, yet my signature is on all kinds of educational documentation that they will bring out on the record for future use for medical reasons. What is all this ambiguity, and why is it construed such ways? I'm not clear on it. Can you clarify this stuff? I'm sorry, I don't comprehend that either. I don't comprehend your Title 42. Can you pinpoint that for me? Because as far as I read in Title 42, which is the Health and Welfare Act, which is basically my own spiritual concern, I have the right to decide, make my own choices in regards to my spiritual health and welfare. And that, of course, is directly relevant and related to my own health and well-being in the physical form, as well as emotional and logic and rationale. So let's sit down and talk about this, because you mentioned here is termination and non-renewable events, but you don't speak about cancellation. So let's speak about it. What's this bankruptcy about? Well, isn't that kind of rather ambiguous too? Because as a franchise, aren't you supposed to have something backing that public charitable trust we're talking about? Isn't that what I'm operating in? Isn't that why the public, the county attorney comes forth and prosecutes all these cases? Because he's the public trustee? Isn't he bringing me forth in these courts in matters of public trust negotiations, arbitration? Then let's arbitrate. Let's find out where I'm compensable for my signature, for giving a signature under the presumption of performing of the functions of a public office. Specifically, trade or business, performing the functions of a public office. The public office, as far as the body politic is concerned, is, again, like I said, purely seeking economic substance. So it hypothecated the name from a spiritual existence to a commercial existence. Only I have a right to do that. If I want to operate my name commercially in a commercial system as Keith Orland Little, I will do so. If I decide to do it as Mark Twain instead of Samuel Clemens, I'll decide to do so. That isn't for the state to determine. If I decide to use a symbol instead of being known as formerly known as the artist formerly known as Prince, if I want to use a symbol instead, that's up to me. That's my choice. That's my spiritual decision. I get to determine what my word is. I get to discern how to artfully draw my word. And then we'll see who's babbling. Because as far as I see it, my word is his word. Love thyself love thy neighbor as thyself, and love my God with all my heart, body, and soul. And if I love myself in that sense, and I want to get over the anger and the emotions and everything, then I have to start thinking about these things in a logic and rational manner. And in doing so, I have to bring it to my brothers in a logic, rational manner. And I hope that's what I'm doing. Because I don't want to, like I said in my apology video in regards to being belligerent, I don't want to sound belligerent. I'm working hard on making sure that I don't cuss anymore. And live my life in that way, in that perfect way. And this is how you do it, is you perfect the record. You point out the folly in their record, in that, well, it can't possibly be because there's no actual chain of title here. I mean, how can you have this in your, quote, court of record known as a health records, and then portray it as a civilly dead entity, while the live entity is acting as the franchisee, without fully knowing, and thereby can't willfully and intentfully commit public acts, period. All public acts shall be recorded. And that's why they ask for your signature. Otherwise, you arbitrate things and make binding agreements that somebody else signs. third party. 3 witnesses. You have the 2 witnesses making the agreement and the third party binding it. Private arbitration agreements, that's your contract. And that's a finalization of the terms and conditions of the contract, stating who benefits what. See, these courts are setting out judgments of penalties, which are detriment. And they're all acting in commerce. Contractual. That's fraud. No contract is to be put forth with detriment. Think about it. The elements of a contract provide that there is equal consideration for equal benefit. And if detriment come along, it is no longer valid. Unless parties are willing to suffer that detriment. Suffering is an act of will. You willfully do it. If you don't wish to suffer, then step out of her. Learn this stuff. Comprehend it. Anyway, just wanted to put that out there real quick. Sorry again, it got longer than I wanted to. But a franchise relationship starts with the birth certificate. They're offering up the states as franchises, the counties as franchises, municipalities franchises. There's another section in the United States Code that we can look up franchise and see it has to do with authority to award franchises in regards to public easements and accesses for your utilities and cable and phone wires and stuff. It all has to do with franchising. And that's why your municipalities have those easements and why you are presumed to be a United States citizen under that easement and under your checking that box. I'm a United States citizen. I was born in Iowa. Here's my residence. I'm an Iowa resident. Therefore, a state citizen and a United States citizen, fulfilling the part of the duties of that franchisee. But not all of them. You haven't taken an oath of allegiance. You haven't filled out the proper application. You're not actually performing functions of public office. So think about this stuff, people. It's very important to be able to upgrade your reading comprehension. So again, here I'm going to mention, get yourself a 1611 edition of the King James Version of the Bible and a concise English handbook. Learn how to speak this stuff in the very simplest terms so that you can comprehend His Word better, so that then you can turn around and comprehend all the misconstruction and all the ambiguity and confusion that they're putting on you, and realize that none of it has any real enforcement. Really, you're doing it by your own credit. You're the one giving the system credit, when in fact you are the actual secured party creditor for all transactions, whether they be simple commercial transactions, contract transactions, secured transactions, blah blah blah. Every transaction you commit to, you are the true authority. Qualify it. Let them know by becoming learned, so you can walk this stuff in experience and gain the wisdom to pass it on. Pure and simple. And like I said, this is all stuff I'm still learning too. I'm currently putting my PMA together and getting that all structured, and when I get it finalized, we'll be discussing more on that to hopefully help others grasp what it takes to do this. You're going to create your own little corporations. And you don't need a mommy to do that. Each man, ye are creators, ye are gods. In and of yourself, you can create a fiction. In and of yourself, you can create several fictions. In and of those creations, you can create fictions that work and operate together to do all of the functions you need to perform in life. to conduct all of the affairs in your life. Now, if you want a companion, a life companion, it would be wise to have somebody like that in the physical realm. But you don't need it in the legal realm. That's another fiction of the marriage license. It helps create a secondary parent corporation as two franchisors. Great. Now we get a franchise within a franchise within a franchise within a franchise, and nobody knows who's liable. When you become the authority, you know exactly who's liable, and you know why you're liable, and you're willing to be liable because you're carrying His word in love, and you love thy neighbor as thyself, and you love him with all of your heart, body, and soul. And you just simply perfect the record. Easiest way to perfect the record is find the errors. So think about this, people, and remember, if it weren't for you guys, I wouldn't be doing this. God bless you. Love you. Have a great day. Bye.